An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
Does the First Amendment protect offensive speech? United States v. Stevens, 2010. Brown v. Entertainment Merchants Association, 2011. Over the years, the Supreme Court has held that certain categories of speech are unprotected by the First Amendment. For example, speech that incites violence, the use of fighting words, and sexually explicit speech the Court has defined as obscene. In this topic, we will discuss attempts to identify another new category of unprotected speech, extremely graphic or, quote, offensive depictions of violence. Let's start with U.S. v. Stevens, 2010.
Respondent Robert Stevens was indicted for selling videos depicting dogfighting. He was convicted and sentenced to more than 3 years in prison.
Stevens argued that his conviction violated the free speech clause of the First Amendment. Federal law made
it a crime to create, sell, or possess certain depictions of animal cruelty.
This law did not prohibit animal cruelty. Rather, it only prohibited
portrayals of certain acts harmful to animals.
Specifically,
the statute applies to any visual or auditory depiction, such as a picture, video, or sound recording, quote, in which a living animal is intentionally maimed, mutilated, tortured, wounded, or killed, end quote, if that conduct is illegal where the creation, sale, or possession takes place.
Congress exempted
from criminal coverage depictions with, quoting again, serious religious, political, scientific, educational, journalistic, historical, or artistic value.
The Court observed that Congress
focused primarily on what are called crush videos, which feature the torture and killing of helpless animals.
On appeal, the Court had to decide
whether that prohibition on depictions is consistent with the First Amendment.
The vote in Stevens was 8-1. Chief Justice Roberts wrote the majority opinion. Only Justice Alito dissented. First, the government argued
that depictions of animal cruelty are categorically unprotected by the First Amendment.
In the past, the Court has recognized certain categories of speech receive no protection under the First Amendment, such as
obscenity, defamation, fraud, incitement, and speech integral to criminal conduct.
However, the Court found that
there is no similar history of excluding depictions of animal cruelty from First Amendment coverage.
Therefore, the Court had to decide if the statute violated the First Amendment.
The government urged the Court to apply a test that balances the
value of the speech against its societal costs. We firmly reject that proposition.
Chief Justice Roberts explained that
the First Amendment's guarantee of free speech does not extend only to categories of speech that survive an ad hoc balancing of relative social costs and benefits. The First Amendment itself reflects a judgment by the American people that the benefits of its restrictions on the government outweigh the costs. Our Constitution forecloses any attempt to revise that judgment simply on the basis that some speech is not worth it.
Therefore, the Court reviewed the statute under the so-called overbreadth doctrine. This doctrine allows people to challenge laws even if their speech may be properly subject to regulation, because the laws would also restrict a substantial amount of protected speech by other people. Chief Justice Roberts explained that
the law is overbroad if a substantial number of its applications are unconstitutional.
Here, the Court found that the statute was way too broad.
This law creates a criminal prohibition of alarming breadth. The statute's definition of a depiction of animal cruelty does not even require that the depicted conduct be cruel.
The government attempted to assure the Court that it would only prosecute
extreme cruelty, but this court will not uphold an unconstitutional statute merely because the government promises to use it responsibly.
The court concluded that the federal law is, quote, substantially overbroad and therefore invalid under the First Amendment. Justice Alito dissented. He would not have declared the entire statute unconstitutional.
Rather, he would have determined if the statute was unconstitutional as applied to Stevens' dogfighting videos.
The majority declined to
decide whether a statute limited to crush videos or other depictions of extreme animal cruelty would be constitutional.
After Stevens was decided, President Obama signed into law a more narrowly tailored version of the statute. The Animal Crush Video Prohibition Act of 2010 only prohibited the distribution of, quote, crush videos. Let's turn to our second case, Brown versus Entertainment Merchants Association, 2011. Today, most video games include ratings, such as M for mature. However, these ratings are not compelled by law. Retailers choose to comply with a video game rating system in much the same way that movie theaters comply with a voluntary movie rating system. The failure to comply, however, is not a criminal offense. California sought to change that regime. Justice Scalia recounted the facts of the case.
In 2005, California enacted Assembly Bill 1179, which prohibits the sale or rental of violent video games to minors.
The law included a very broad definition of violence.
Games, quote, in which the range of options available to a player includes killing, maiming, dismembering, or sexually assaulting an image of a human being if those acts are depicted in a manner that a reasonable person considering the game as a whole would find appeals to a deviant or morbid interest of minors, that is patently offensive to prevailing standards in the community as to what is suitable for minors, and that causes the game as a whole to lack serious literary, artistic, political, or scientific value for minors.
Chief Justice Roberts described in graphic detail the nature of these violent video games.
People actively hitting schoolgirls over the head with a shovel so they'll beg with mercy, being merciless and decapitating them, shooting people in the leg so they fall down, pour gasoline over them, set them on fire, and urinate on them.
The vote in Brown was 7-2. Justice Scalia wrote the majority opinion. Justices Breyer and Thomas wrote separate dissents. First, the court found that violent video games are protected by the First Amendment.
The most basic principle of First Amendment law is that government has no power to restrict expression because of its content.
In Ginsburg versus New York, 1968, the court upheld a prohibition on selling sexual but not obscene conduct to children. California based its video game law on the New York law. However, the court found the California law
does not regulate obscenity for children.
During oral argument, Justice Breyer said that this distinction does not make sense. How can the state prohibit a child from buying a
picture of a naked woman, but the 13-year-old child can go in and buy one of these video games
with sexual content? He added,
"What's the difference between sex and violence?"
Study guide. Why should an offensive speech involving depictions of violence be treated the same way as offensive speech involving sex? The court disagreed and declined to
shoehorn violence into the category of obscenity.
Justice Scalia continued,
Government has no free-floating power to restrict the ideas to which they may be exposed.
He noted that
there is no tradition in this country of specially restricting children's access to depictions of violence. Certainly the books we give children to read or read to them when they are younger have no shortage of gore.
Justice Scalia listed several classic examples, including Grimm's fairy tales, Homer's The Odyssey, and Lord of the Flies. In their concurring opinion, Justice Alito and Chief Justice Roberts disagreed on this point. They wrote that there's a difference between a violent book and an interactive violent video game. During oral argument, Justice Alito observed that,
but we have here a new medium, and that cannot possibly have been envisioned at the time when the First Amendment was ratified.
Chief Justice Roberts added,
in these video games, the child is not sitting there passively watching something. The child is doing the killing. The child is doing the maiming.
Ultimately, the majority rejected this distinction. The court held that
California's novel content-based restriction on speech must be subjected to strict scrutiny.
Did it pass strict scrutiny?
It does not pass.
First, the court found that the state offered inadequate evidence to justify this sort of speech restriction.
California has not demonstrated any direct causal link between playing violent video games and actual harm to minors.
Instead, the state could only cite studies that showed,
at best, some correlation between exposure to violent entertainment and minuscule real-world effects.
Second, the court also found that the law is under-inclusive. It fails to actually solve the problem the legislature purports to solve.
The California legislature is perfectly willing to leave this dangerous, mind-altering material in the hands of children so long as one parent, or even an aunt or uncle, says it's okay. That is not how one addresses a serious social problem.
Third, the court found that the law is over-inclusive because
not all the children who are forbidden to purchase violent video games on their own have parents who care whether they purchase violent video games.
He added,
while some of the legislation's effect may indeed be in support of what some parents of the restricted children actually want, its entire effect is only in support of what the state thinks parents ought to want.
The court concluded that California's approach
is not the narrow tailoring to assist parents that restriction of First Amendment rights requires. Justice Alito has filed an opinion concurring in the judgment in which the Chief Justice joins.
They found that the statute's definition of violence is unconstitutionally vague. Specifically, the law, quote, failed to provide the clear notice about what speech is prohibited. During oral argument, Justice Alito asked Paul Smith, the lawyer for the Entertainment Merchants Association,
Your argument is that there is nothing that a state can do to limit minors' access to the most violent, sadistic, graphic video game that can be developed.
The lawyer answered that a content-based restriction on violent video games could not survive strict scrutiny. In their concurring opinion, Justice Alito and Chief Justice Roberts wrote that the state could write a more narrowly tailored statute to protect children from violent video games. Study guide. Whose speech is being restricted by this statute? Do adults have a constitutional right to speak to other people's children?
Justice Thomas has filed a dissenting opinion.
Justice Thomas found that the practices and beliefs of the founding generation established that the freedom of speech, as originally understood, does not include a right to speak to minors or a right of minors to access speech without going through the minor's parents or guardians. Study guide. Does Justice Thomas identify any historical examples of legal restrictions on speaking to minors?
And Justice Breyer has filed a dissenting opinion.
He found that the statute survives constitutional scrutiny because of evidence provided by social scientists.
And the American Psychological Association and the American Pediatric Association have said that certain kinds of video games here create violence when children are exposed.
Even if the issue is debated, he would have deferred to the legislature.
But if I can say, could a legislature have enough evidence to think there's harm? The answer is yes.
The violent video game law was sponsored by State Senator Leland Yee. Ironically, he was later sentenced to 5 years in prison for, quote, promising votes and guns to an undercover agent who was funneling him contributions. Stevens and Brown both show how reluctant the Supreme Court has been to add any additional categories of unprotected speech.